Hello guys, it's Anthony Bandier here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing a Roadside Chat. This question comes from an officer in Tennessee, and he says, hey look, what kind of questions can I routinely ask during a traffic stop without violating people's constitutional rights? It's an excellent question. Let me give you some examples about what is constitutional and so forth. Now, first of all, we start with the premise that you're allowed to take the time necessary to issue a traffic ticket, check on the driver's license, determine whether there are outstanding warrants against the driver, and inspect the automobile's registration and proof of insurance, right? That comes from the U.S. Supreme Court case called Rodriguez versus United States, 2015. But also, you can't go off mission, right? I mean, really, you get to do those things reason related to the reason why you stopped a person. So if you are going to stop the person for speeding, but you have this hunch that they're also involved in other criminal activity, that hunch does not allow you to conduct other investigations, right, that add time to the traffic stop. And that's another thing I want you to realize, is that Rodriguez is all about topic, not time. It does not care necessarily that you ask an off-topic question. It matters, does it add, if it is off-topic and has nothing to do with the mission of the traffic stop, is it adding time? If it's adding time, you can't do it unless you have reasonable suspicion or the person's consent. Now, there are ways to ask off-topic questions without violating Rodriguez, and mainly those ways are A, asking for consent. Hey, can I ask you something off-topic? Can I ask you something about something that you're in your car, right? Multitasking, that's where you're writing the ticket and you're talking. That's what most interdiction officers are doing. They're writing their ticket while they're talking to the person, trying to build reasonable suspicion. Number 3 is unavoidable downtime. That's when you are waiting for something to happen, like dispatch to give you the warrant check. You can talk to the person about how's the weather and so forth, right? And then finally, with a backup officer, the backup officer is the one, talking to the occupants, getting more in depth about where they're coming from and what they did in the other town that they just came from, while you are writing that ticket. That, by the way, is the best way to pursue these hunches without violating people's rights. Asking about criminal history is also allowed. Hey, have you been arrested before? Oh, you have? For what? Why? Because it's also about completing the mission safely. Asking routine travel plans are upheld. That's United States versus Martin, the 7th Circuit, 2005, right? Asking questions about the purpose of the trip and where you came from and so forth. Asking about the relationship of the driver and any passengers is permitted. That's United States versus Rivera, 10th Circuit in 1989. Asking about the relationship of the driver and the passenger, I already said that. Requiring proof of insurance for the vehicle. That's United States versus Brigham, right? That's 5th Circuit. Every state has that. Asking the driver to sit in the patrol car for questioning and for issuance of the citation is permissible. United States versus Ramos, 8th Circuit, 1994. However, here's the deal. You can always get a person out of the car, right? You don't need reasonable suspicion to get people out of the car in most states. Some states are like, with the driver, no state restricts the driver. Sometimes asking the passenger out in some states is a problem, like in New Jersey, but most states are not restrictive. You can get the people out. However, if they do not want to sit in your car, you can't force them. Obviously, they don't have a legal obligation to sit in a patrol vehicle, unless you have reasonable suspicion that they're involved in criminal activity, and you can detain them in a patrol vehicle. Request a computer check on the driver's criminal history. The check should be requested at the initial stage of the stop. At the same time, the driver's license is requested. So otherwise, if you run them for wants, and then later you ask for III, NCIC type data, the question is, why are you now doing that? I mean, now it just seems like it's out of sync. That is United States versus Estrada, 5th Circuit, 2006, and United States versus Salazar, 8th Circuit, 2006. Inspecting the VIN, right? But you have to be least intrusive. That's New York versus Class, United States Supreme Court, 1986. So this is an example where you have the paperwork for the vehicle and you can see the VIN on the dash. You do not get the right to just open their door to inspect that placard, right? You don't need to do that. However, if the VIN is covered, right? Or the VIN looks suspicious, it looks like it's has a cold VIN on there or something like that, then you can inspect the VIN. That's New York versus class. So I hope this helps. Keep the questions coming. You can ask me more questions at bluetogold.com /show, or you can visit us and watch us live. We do a show almost every week called the Search and Seizure Show. That's where you can also ask your questions live and so forth. Before you leave, I'm going to ask you a favor, okay? I work hard for you guys. Do me a favor. Give a little love back. Hit like. It shows YouTube that this is valuable, so other people similarly situated will pop up in their feed. Subscribe. Share with your friends. Hey, check out this guy. He's teaching us good case law. All right? I appreciate all your support. Until next time, my friends, stay safe.